Welcome everybody to the Lunch with Liz. I'm sure we'll have a few people jumping on as we get started here, but I don't want it to delay too long. If you aren't on mute, if you could mute yourself, there will be an opportunity for you to come off mute if you need to, but go ahead and just make sure you're muted for the time being. If you need to come off mute at any time and ask a question, feel free to do that though. But welcome to November's Lunch with Liz. I'm Liz Moneymaker, and yes, that is my real last name. I did not make it up. I promise you, it was my dad's name and his dad's name and many generations before that. I'm getting a little into genealogy, so if you want to get really bored sometime, just call me and I'll explain exactly where it all came from. Uh, I am an attorney. I do estate planning and probate and Medicaid planning. I have an office in St. Petersburg, Florida, but I serve everyone in Florida pretty much. We do both virtual and in-person appointments. So why am I sitting here today talking to you? Well, 3-ish years ago, maybe going on 4 now, I saw what I considered a real need to be able to really have conversations with people, not just doing blogs, not doing podcasts, but having an opportunity to have a lunchtime conversation where we could make sure that a lot of the myths, confusions, and untruths about estate planning could be laid to rest and where people would have an opportunity to ask questions. So that's how Lunch with Liz was born. I do have people respond to the advertisements asking what is going to be served for lunch. In case you're not aware, there's no actual lunch that I'm providing. So it's a BYOL on lunch with Liz. So how does it work? Well, first we're going to have a little bit of a presentation on the topic, and then we're going to open it up for questions. Those questions can be where you come off mute and we talk. They can be where you type them in the chat. Either way. And you don't have to come off video if you're one of the people that I see that are shy right now and have no video on. That is totally fine with me as well. The most important thing for me is you saw this, you either got an email or you saw it on social media, and for some reason you're here today. I want to make sure you leave today with whatever question, whatever information you wanted to get, that you get that today. So that's my most important goal. Please note that this is recorded. I'm not saying that to quash any questions at all, but it is going to be recorded. So if you want to watch it again later, or you want to share it with family or friends, you can find the video on our webpage. Usually it shows up about midweek next week. You can also find all the past Lunch with Liz's, at least for the past year or so, also on the website. We have a lot of great topics like estate planning 101, the difference between a trust or a will, estate planning for women, etc. So today, though, we are going to be talking about fiduciaries. And we're really focused on 3 specific roles here today. 1, a personal representative for a will. This is also sometimes called an executor. 2, the agent under a power of attorney. Some people in a slang way will just say, who's your power of attorney? The technical term is an agent under the power of attorney. So we'll be kind of using those terms interchangeably. And the third fiduciary role we're going to talk about today is your healthcare surrogate. Also can be called a healthcare proxy, also can be called a medical power of attorney. There's a lot of verbiage in there. So I want to make sure that you leave today understanding that they may be called different things, but they're essentially an agent under one of these 3 documents. The first document is the last will and testament, which dictates what happens to your stuff when you die. The second document is the power of attorney. This is for when you're alive, so that you can name someone you trust to make financial decisions for you. And the third document is your healthcare surrogate, which allows you to appoint someone to make medical decisions for you. I am very lucky today in that I don't have to talk this entire time because I have a very exciting special guest with me, Kathleen Seide. Kathleen is a professional fiduciary, meaning that she does the role of executor, the role of an agent under a power of attorney, and the role of a healthcare surrogate in her professional capacity. Kathleen, I want to welcome you to the show.
Thank you. I'm really excited to be here.
Awesome. If you could explain first to our audience, what is a professional fiduciary? What makes you different than just anybody who may have that role?
A lot of people that choose to hire a professional fiduciary instead of someone they know, family member, that sort of thing. There's a couple different reasons for that. Sometimes they've kind of aged out of their friend group or their family. So there's just not a lot of people in that trusted role for them to choose from. And sometimes the people that are in those roles aren't necessarily qualified to do the job that I do. So they bring in a professional to take care of that. Other times they're just wanting to make sure their family has the space to grieve and deal with their own things that come up as these transitions happen. And so they have a professional fiduciary in that role so that they don't have to burden their family with these things.
Excellent, excellent. So why don't we just get into the thick of things so we make sure we have plenty of time for everybody's questions if they have any. Let's talk about the power of attorney first. So just to
Okay.
remind everyone, the power of attorney is a document that is used while you're alive to let somebody else make financial decisions for you. These can be banking decisions, investment decisions, dealing with the IRS, dealing with Medicare, selling a house, etc. From your experience, Kathleen, can you elaborate on what you have done as a power of attorney or what you've seen other people do in the role?
Absolutely. So in any of these roles too, I just want to say that as a fiduciary, I am a person who has an obligation to act in this other person's best interest. So like the role of fiduciary means that I'm making decisions and I'm taking action where that my beneficiary or my client's best interest is prime in everything that I'm doing. And so, that requires trust, good faith, honesty, and there's a lot of standards that have to be met to do that properly. In the role of power of attorney, there's a lot of situations where I have clients that as they age, dealing with their finances starts to become overwhelming or confusing. And so they want to have a second set of eyes, or they just don't want to be bothered with it, maybe. I have some family situations where mom or dad isn't quite great with money and they maybe got in debt. They were getting behind on bills. They were losing things. And so they bring me in to help manage that. And I also will look at, statements and things like that to make sure that there's not any elder abuse going on where somebody may be communicating with them and your money starts disappearing. And, if you don't keep an eye on the accounts regularly, you might not notice. I have some beneficiaries where we have, I have an account, they're a joint account holder, but we've agreed to keep it, you know, kind of confidential from the actual client because they have like gambling issues or something like that. And so they want to put me as a barrier between them and their money to make sure that we can protect that for them and for their long-term care, right? So that they're going to have money when they need it down the road.
Right. Thank you for that. And I want to just make sure it's clear to everyone on and anyone watching it later that Kathleen's talking about this from her role as a professional fiduciary. But if you are in the role of power of attorney, this is exactly what you would be doing as well. And if you are choosing someone to be your agent under a power of attorney, these are the things that they would be doing. So she's not talking about something unique that she does as a professional fiduciary. I want to make that pretty clear. So if you were, as someone who does it professionally, if you were choosing someone to be your agent under a power of attorney, for example, based on your experience doing the job, what are some of the qualities you would want that person to have?
Yeah, that's a great question. And I think some things that really matter. that people don't necessarily think about because usually they just name somebody that's close to them, somebody that they trust, or someone that knows them well. But you really want to have somebody who they're very reliable. You'd like to have somebody ideally who can say no under pressure and or like stand up to authority figures because this person is going to be stepping in and making sure that the way that your finances are invested matches what your estate plan is. And maybe the way that you had been doing it doesn't really line up with how it needs to be as you're aging or ill moving forward. So they need to be able to talk to your financial advisors and get advice and ask difficult questions and maybe change who the advisor is or something like that, depending on whether the fee structure makes sense, stuff like that. So it's like there are awkward and difficult conversations that you sometimes need to have to protect your the person who is the principal in the document, and so that person needs to be able to have those conversations and navigate that kind of thing. Strong boundaries, that kind of stuff. They need to be really organized and very good with paperwork because a lot of what is important about serving in this role is the being able to document your thought process and being able to track and account for all the funds, make sure there's no commingling of funds, and be really strict with how finances are managed. And so, everything that you do should be documented so that if something comes up or there's any questions about it, you can go through and show, hey, here's why I did this. Here's the thought process. Here's the logic behind it. And it's not like there's always a right or a wrong way, but it has to be a thoughtful way, and it has to be that you're considering their best interests and you're considering their estate plan, and all of that goes in together. So somebody that's not great with documentation and paperwork and organization isn't going to be great for that role. You ideally would like somebody who can communicate without a lot of drama. So they're going to de-escalate situations rather than escalating them. And there's just a lot of intense emotions around these issues. And usually when these transitions are happening, everybody gets triggered, for lack of a better word. And so somebody that can manage that and navigate it without making things worse is really important. And then the last piece would be a lot of times it's easier if their proximity is close, if they're nearby and they can actually come knock on your door or be around and go sit with you at the bank, stuff like that. It's not requirement, especially in this day and age. Some people can do it remotely better, but definitely having the availability to do it, the time to dedicate to it is number one priority. But somebody that's closer than farther away, especially if they're not a professional, it's going to make it easier to do that job.
Yeah. So what would you say to someone who, oh, look, mom just sent me her power of attorney and I'm it. What would you suggest that they do to prepare for the role?
What I would suggest is Stetson and the Professional Fiduciary Council of Florida just released a course for the public in situations like that. So I would suggest go and check out that course. It's like a 2-week online course. There's, I think, 6 modules, each with an hour video, right? Some questions and answers. And it's a great start to giving you some context for what your job is, what powers you do and don't have, where the lines are drawn for what you should and shouldn't be doing, how to interact with other people that are in fiduciary capacity for the same person, and get yourself set up to be successful in that role. So I think there's a certificate version and a lower, like a non-certificate version. I think it's maybe $200 or $300 for the course if you don't want a certificate with it. But I was involved in putting the course together. I'm on the board of directors for the Professional Fiduciary Council, and so I was involved with putting it together. And we're really proud of it, and I think it's going to have a big impact. And it's exactly for that kind of situation.
Could you, we have a question about what was the name of the course again?
It is serving as power of attorney, and it's not a Stetson law class. It's a public access class. So if you look up Professional Fiduciary Council of Florida, they've been posting a lot about it. You can find a link to it from their website. It was a little bit harder for me to find from the Stetson website because they've got so many courses on theirs.
Well, Vicky, if you get a chance while we're on today, maybe you could throw that in the chat to help people find it if they'd like to use it. I do want to highlight some things that I found in my practice. Number one, if you have children and you're appointing a child and they don't get along with the other children, that can be a situation where I might suggest that you either name a professional fiduciary or you name someone other than one of the children. I also have clients that to make anybody mad. I will not do co-agents under a power of attorney, mainly because so many institutions, banking institutions, financial institutions won't recognize two, or they'll make it very difficult. Both powers of attorney have to show up at the exact same time. And one lives in Colorado and one, lives in Utah. And it's extremely cumbersome and doesn't really accomplish what you want to accomplish under the power of attorney. Kathleen, have you run into anything like that?
Yeah, absolutely. I won't serve for the most part if it's a co-situation because of the difficulty of it. And the liability, depending on how the document is written. Yeah, I think a lot of people make the mistake of trying to, you're trying to keep the peace and make everybody feel loved, and you're all equal in my eyes, so I'm not going to have a hierarchy. Where it's really better if you have multiple people to have it set up where one person is doing all the things, and then you have a successor who would do all the things if they can't. And they can always communicate with each other and collaborate on decisions, but according to the document, the buck stops here. And I think it's really important to have those clear distinctions.
Yep. Thank you about that. And Vicky did just put information on that course in the chat for those of you that might be interested in that. One other thing I want to bring up about powers of attorney before we move on is Florida does not recognize what are called springing powers of attorney. And those of you that may have moved from another state, you may have got a power of attorney that says this document only comes into effect if I become incapacitated. And I'll have clients come into my office and they'll like, I don't want my power of attorney to have any power until I can't think for myself anymore. Florida does not do those anymore. Once you sign the power of attorney, it is in effect, which is another reason why selecting an agent under a power of attorney is so important, that you have someone that you trust who's loyal. And when they need to act, they can, and they're not going to act before they need to. I think I'm going to move on and we're going to save questions till the end, unless you have a real burning question you want to make sure you get asked about the power of attorney, in which case I'll pause for a second. Okay, we're going to move on then to healthcare surrogates. We'll open it up for questions at the end for all the topics will be on the table for sure. So reminder about what a healthcare surrogate is. It is the document that lets you dictate who is going to make medical decisions for you in the event you cannot make them yourself. Oftentimes we select our spouses and then we select children, but sometimes we don't have those people in the roles. Kathleen, if you could just kind of highlight some of the things that a surrogate would do. I know a lot of my clients initially jump to pulling the plug and end of life, but it's about a lot more than that, isn't it?
It really is. And, honestly, I mean, I see a lot of people at end of life, they're still able to make their decisions until the very end. But, it's about, like I have a client who I'm, agent under power of attorney and healthcare surrogate for, and she's technically competent, able to do this stuff, but she's a little mentally impaired, and it's just a lot for her to process, and she's really slow in communicating. So, she leans on me for a lot of that a support there. So it's not that I necessarily do things without her involved in that decision making process, but her doing it without somebody sitting at her side would be really overwhelming for her. So it's sort of a collaboration rather than me having that power only. And I think that that's a lot more common where people, you kind of come and go with your capacity, and you're not necessarily incapacitated, but it's just as we get sick and as we get in these situations, there's just so much energy that you have, and sometimes just showering and feeding yourself takes up 90% of that. So having somebody that you can trust to help support that and help keep an eye on things. And when I'm serving as healthcare surrogate, I bring in a team. Like, I'm not a healthcare professional, so I am familiar, and I've had a lot of experience in that area as a person. But I bring in a care manager, and I bring in caregivers as needed to help support somebody. So that care manager is going to be taking my client to the doctor and actually sitting there, like, where when I have a family member myself, like, in the past, I would go and I would sit at the doctor and I would take all the notes and I'd write all the questions, I'd do all that. That's what your care manager, that's what I would be doing if there's not a care manager involved. So, you need to have that second set of eyes to advocate for you, that second brain to advocate for you through that whole process. And I find that even for somebody that's a lot younger, it's a very overwhelming process. So having someone sit next to you through that is really helpful. And a lot of people are lucky enough to have family and friends and spouses and stuff to do that. But when you don't, I think that having extra support is really going to benefit your outcome and benefit your quality of life.
Absolutely. I often say, who's going to be that squeaky wheel in the hospital room or the doctor's office that's going to demand another test or demand a
Yeah.
different room because that one's noisy? So who's going to be that advocate in the room versus not necessarily the one that's going to pull the plug for you in the end? What type of qualities would you suggest someone look for when they're choosing the healthcare surrogate?
Similar. So for me as a professional, I will only serve if I'm named as both.
Mhm.
Both the and I mean durable power of attorney and healthcare surrogate, because so much of what they do go hand in hand. Um, and so a lot of those items that I listed kind of go together. You need somebody who, compassion is a big one, and patience, I think, with healthcare surrogate on top of the rest of it. But somebody who's, not only willing to de-escalate and listen and understand what your values are, but also somebody who's, you got to be able to sit there with a doctor and say, no, no, you can't leave the room yet. I still have questions. And a lot of people aren't comfortable doing that with authority figures, and doctors, fit that a lot. So most people get pushed around a lot in that medical world, and it's unfortunate because that changes their outcome.
Would you suggest if people have someone with healthcare experience that that be who they choose, or is that just one facet?
I think it's one facet, and I wouldn't have that split up naming somebody. So I would prioritize having the same person named in both documents. And a good example is maybe you have a son that's in business or an attorney or accountant or something, and a daughter's a nurse, right? And so you want to name her as this and him as that. And I think it's better to name one person as both and then have the other one as a successor. And having that medical experience is important, but I think it's so varied depending on what your illness is and stuff. You can't really plan for it and have somebody that's going to be an expert in all of those things. You just need somebody who's good at that process and good at taking in information, being able to process, to digest it, and come up with important, good questions, and help decipher what your options are and why, and figure that out. It's more of a process than knowing all the ins and outs of the medical world.
Yeah. So same question as from the power of attorney. I'm open my email and there's the email from mom and oh shoot, I'm her healthcare surrogate. What are some of the things that I would want to make sure I do to make sure I could do that job effectively?
Yeah, that's a little bit trickier. So with the healthcare surrogate, you want to make sure all people that are involved know you exist,
Mhm.
right? So, you want to make sure that her doctors know that you're the healthcare surrogate, and any care providers know that. You want to make sure that if the mom goes to the hospital, you are there with physical written copies of them to hand, like print them out and bring a couple and hand it to the ER, hand it to the floor nurse, hand it to everybody, because it's really hard to get them to recognize and actually communicate with you. So if you're not sitting there as the healthcare surrogate, they're just going to put some notes in the, computer, and that's that. They're not going to necessarily call you and give you updates as things change. And if you give this paperwork to the ER and they're doing it right, it doesn't mean it's going to get transferred up to the floor when she gets transferred because, the paperwork is a day behind the person. So you want to make sure that you're meeting and communicating with everybody and that they're on board with including you as a healthcare. It's a really important first step that a lot of people miss.
Yeah. And how do you, as a surrogate, then know about your client's wishes? Like, is that a meeting that you have?
Yeah. So as part of the onboarding process that I do with my clients, that's a whole section of if I am named as healthcare surrogate, I spend some time talking about that information, what their values are, what they see for their long-term care, aging, do they want to age in place or not? What kind of family history do they have that we should be watching out for? And then considering what their age is, how frequently do we need to do check-ins because your health is going to be shifting over time. Um, yeah. So, and it's like you said, most people jump to pull the plug, like, and there's so much more to that conversation. And, the more you're living it, the more nuanced those discussions become. And so until people have lived it, it's really hard to get them to get granular with it to that level. It's like, well, if you have dementia, do we want to give you new dentures? Do you want that oral surgery? Like those are the kind of questions that are difficult to answer as a healthcare surgeon. You got to kind of sit with and figure out.
Yeah. So as an aside from that, there are very detailed things that you can do as a consumer out there to make your wishes known. There are dementia guidebooks that you can do checklists about what type of care that you want, what type of treatment that you want. And the more information that you can have to give your surrogate, whether it's professional or your own family, about what your wishes would be, and you do that while you're of sound mind, the more guidance they're going to have. I know as a child myself of ill parents when they were, I know that there was a question sometime about what they would have wanted at a particular moment when they couldn't articulate it. So to me, that's one important thing as a healthcare surrogate is that you find out that information if you can, while they're still able to articulate it.
And an interesting point off of that actually is in a lot of these documents, the standard is, their best interests, where with the healthcare surrogate, the standard is what they would have chosen, right? So, I'm supposed to be acting in not just in their best interest, but using the decisions, using the values of what they want. So somebody that uses naturopathic medicine and doesn't want to get on chemo, right? Like, even though the healthcare standard for this thing is chemo and everybody would recommend it, I've documented this person is very clearly doesn't want that kind of care. They want to go get acupuncture instead, right? And so that's the kind of care that I choose for them because of the conversations that we've had.
Yeah, perfect. And before we move on, the same concept under a healthcare surrogate as a power of attorney is I really do not recommend co-people, two people acting. Somebody has to be the decision maker. Somebody has to be the point of contact. I know a lot of my clients, they don't want to pick one person over the other, but I really strongly encourage them to do that because ruling by committee just never works.
Yeah, absolutely. And honestly, if they don't agree, then it puts your medical team in an awful position and
Yeah,
they basically have to go do it a different way.
yeah, exactly. All right, we're going to move on to our third fiduciary role. And again, we'll be opening this up for questions here in just a few minutes. So the third role is a personal representative. This role is also called an executor in some other jurisdictions. I'll probably use both terms over the next couple of minutes because I'm just used to using those. This is the role of serving to ensure that the wishes that you put on your last will and testament, or if you die without a will, you could still have a personal representative appointed. This person carries out the wishes you have in your will, or if you don't have a will, carries out what Florida law says should happen to your things. So keeping this in mind, the difference between this and your power of attorney is the power of attorney is while you're alive. The personal representative is after you've passed, and now we have to take care of your assets. So I've served as a personal representative before. I know Kathleen, you have as well. It is a thankless job for sure. Could you highlight some of the things for our audience about what you typically do as a personal representative?
Yeah. So as a personal representative, first you don't really have any authority until the court gives you the letters of administration. And once you get those letters in your hand, then you hit the ground running. And first I'm looking at protecting and preserving property. So I want to get an idea of what is owned in the like what's in the estate and make sure that it's secured and protected as best as possible. So a lot of times it's, is there a home? Is the home locked? Is the AC running or is it flooding or are the utilities on or the neighbors there? Is there somebody living in it? Does the property inside belong to that person or to the estate? There's a lot of interesting questions there. Looking at, investments, trying to figure times I'll start going through mail and looking in their files and stuff like that. So I'll go to the property and get access to that and start looking at trying to gather information about what is even Usually the ones that I've served in so far haven't been clients that were inactive cases that then passed away. It's, you know, somebody is a beneficiary, there's a court appointment for me. And so it's somebody I didn't have a relationship with, and I'm going in completely blind. So it's like looking for, is there life insurance payouts I need to go after? Are there vehicles? Somebody took a vehicle and now I need to go do a police report and track that down and all kinds of stuff like that. But it's really about securing those assets first and getting an inventory of what exactly is in the estate to start with.
Right. And just to give a little bit expansion about the probate process. So when someone passes, if they have assets that have to be probated, that's when the personal representative comes into place. The Let's take Pinellas County, for example. We would petition the court to open up a probate. The judge would then typically 99% of the time require the personal representative to have a bond, and then they'll issue the letters of administration. That was the question we just had in the chat. It's called letters of administration. I like to call them your driver's license to be a personal representative. Until you have that driver's license, those letters of administration, the bank's not going to talk to you. The investment financial advisor is not going to talk to you. The government's not going to talk to you. So that's the key document that you would need as personal representative. When you're appointed personal representative, you have an obligation now to the estate, to the beneficiaries of the estate, and the creditors of the estate. It is a lot of hats that you're wearing, and none of those things take priority over the other. So when you're appointing someone to be personal representative, you definitely want to have someone that can balance all of those. Same question as before, Kathleen. When you're choosing someone to be your PR, your personal representative, what kind of qualities would you be looking for?
I think on that, documenting paperwork and tracking finances are a stronger, more important skill set to have. Um, a lot of what PR does is more guided by the attorney that's involved in the probate. So there's a little bit less of like needing to have strong boundaries and stand up to authority kind of thing, but more just being very detail oriented, organized, documenting everything, keeping track of where funds are, making sure you're not commingling and being very transparent, especially if there's a lot of beneficiaries. I had someone I know had was one of 14 or 15 beneficiaries, and one of the family members was the PR and did a great job, but after the fact people were like, yeah, well, they charged too much for this or they did that. Like, you need to track your hours really clearly and just make sure it's really transparent so that there's no hard feelings and everybody feels like hopefully grateful for the work that you're doing.
Absolutely. And same thing that you said about the power of attorney, it needs to be someone that has the time.
Yeah.
When I have served, I've spent hours in banks,
Oh yeah.
even when I had an appointment to try to get accounts closed and find out where money went. going through household furnishings and stuff like that, trying to get rid of the stuff in the house and sell the house. It can be pretty close to a very hefty part-time job, if not a full-time job for sure.
Absolutely. Well, and it depends on how quickly you need to get it done, right? So it can be a full-time job for a month or a part-time job for 6 months or, but it is a lot of time. And yeah, like you said, if somebody doesn't have the time to dedicate to it, it's going to sit there for 2 years.
Absolutely. The key thing about a personal representative in Florida to keep in mind, this doesn't apply to the power of attorney or the healthcare surrogate, but to serve as a personal representative in Florida, you either need to be a resident of Florida or you must be related to the person for whom you are serving. So I find this a lot of my clients will come in for their initial consultation and they're naming their best friend from college who lives in Massachusetts, or their neighbor that from Ohio, and that won't work. To be an executor in Florida, you have to have one of those two qualities. You either live here, a resident, or you're related to the person who's appointing you. Anything else on being an executor before we kind of open it up to questions?
I would just say lean heavily on the attorney that you're working with. There's a lot of people, especially in executors, there's a lot of people from the public that are serving in that role. And, it's like, doesn't hurt to ask the attorney. I know people kind of lean away from it because they're afraid of the cost, but, it's so much better to do it right than to make some mistakes and have to clean it up later.
Absolutely. And I know myself typically, and a lot of lawyers who do probate will do flat fee. So there's no reason at all not to call us to get advice for sure. I do want to open it up to questions. So let me see. I know we have some in the chat already. So let me see here. We have a question. Me and my brother and I are 50-50 beneficiaries of my dad's trust, and he is the executor who has not provided me the funds of sold real estate. Is there a statute of limitations for litigation in Ohio? A couple things there. Thank you for that question. But here, number one, I don't know anything about Ohio law. And number two, we're talking about being a personal representative under a will here, not a trustee under a trust. I purposely didn't include that in this discussion because that's a whole different type of role. We do have trust lunch with Liz's where I explain the trustee role and that kind of stuff, but that's not what we're doing here today. And I wouldn't be able to answer that question anyway. I'm sorry, because I'm not an Ohio litigator. So I'm sorry about that.
I would
Yeah.
suggest contacting an attorney in Ohio and spending a little bit of money to have them review the documents and ask.
Right. If you're a beneficiary, you can hire your own lawyer and
Yeah.
then have them make sure that the laws are being followed. I was told the requirement for personal rep no longer required residency or family member. Is that not correct? No. If you have a trust, does that representative take care of that too? So if you have a trust, you're going to have a trustee under the trust. And if you've been on any of my lunch with Liz's, you know that I think of trust like a bucket, and the trustee is the person that's in charge of your bucket. The trustee under a trust does similar things to the executor under the will, but they're two different people. So Shannon, if that didn't answer your question, let me know.
Well, can you hear me?
Yeah.
Okay. I wasn't quite sure how to word it. So, like, if we have a revocable trust and my husband and I like put that together, we would be taking care of our own things, right? Would we be the trustees on that if we had our own?
If you had your own trust?
Yeah, but yeah.
Yeah, typically when you create a trust, you become your own trustee while you're alive,
Okay.
and you have listed someone to take over when you pass away.
That's what I'm confused about. Like at that, if we die, does a representative take over that?
So your trustee would take over your trust duties, and your personal representative that you've named in your will would take over those duties. Sometimes there aren't any duties in one or the other, but you still have to
Okay.
have both roles named. Oftentimes they're
Gotcha.
the same,
Okay.
oftentimes they're the same person, but sometimes they're not.
All right. That clarifies it. All right. Thank
Okay.
you.
Yeah, you're welcome. Levon had a question. In Florida and other states, is a professional representative a you mean a personal representative, a licensed attorney, or certified public accountant, or other licensed person? I can't speak for other states. In Florida, that is not a requirement that a personal representative be a licensed professional. Oftentimes, licensed professionals won't serve in that capacity and will recommend someone like Kathleen, who actually serves as a professional fiduciary. Most of the time, those of us that wear our other hats like lawyer, accountant, financial planner, etc., we just want to keep that hat on. We don't want to wear another one. Okay. Next question. How often should a will be reviewed? It's a little out of the topic I'm talking about today, but I always say with any document, any life changes, you'd want to review it. Deaths, births, divorces, moving to a different state, anything like that, you would want to review to make sure that everything is accurate. Beyond that, I don't really put a timeline on it. You could say some lawyers say, well, you should do it every 5 years. That's probably a good rule of thumb, but there's no requirement for that. See, my brother passed away in Iowa. I have received inheritance of savings bonds. Da, da, da. I am Anthony. Thank you for that question. That is not a question I can answer. I'm not a tax professional, nor do I know Iowa probate at all. I'm sorry. Um, Karen, that's a good question. Kathleen, I'm going to throw that to you. And while we're at it, if you could just start, like if I went to hire you, what would be the process? And then how would we determine fees?
Yep, I can cover that.
Yeah.
So first of all, answering Karen's question about fiduciary costs, it really depends on the person and the company. There's a bunch of different business models that people have. So the one that I have is to typically charge by the hour. And then I have minimums annually or by the case, depending on what the situation is. A lot of fiduciaries will do that. Another typical process for serving is just charge a flat rate or a percentage. So those, I see percentages more common and in larger companies, percentages I think are more common, where hourly fees are more common for individual fiduciaries like me. But that's just from anecdotally talking to other fiduciaries. Um, as far as what the process is and how to hire somebody. So typically somebody is referred to me often by their attorney, like from Liz, and we'll set up a quick like 15-minute consult call to see if we click, if we're a good match. They're learning about me, I'm learning about them. As part of that confirmation for that, I have an automated email that goes out, so you'll get to see my fee sheet and my CV. So you get a and the details of how my hourly rates charge, how I charge for my team, and what minimums are and things like that. And then when we decide to work together, there's an onboarding fee for me. And that's for me to participate in the process with drafting the documents, make sure that some things are named and things that are included in there that I need to work properly, and talk with the attorney if I have any questions about something specific that you've added in your documents. Going through the onboarding meeting with you to make sure that, once we have those documents signed, I want to make sure I understand what your thoughts are. And then, we talk about where all the bodies are buried. Where do you bank? Who are your people? What are your, beneficiary contact information, social security numbers for you, and all that kind of stuff. And then if I'm also a healthcare surrogate, have that discussion about your own views and values. And then most people, in that case, if they're just doing estate planning, that would be considered an inactive case for me. So that goes on a shelf or a virtual shelf. Everything's digital for me. And then, it's inactive. And, we do touch points every so often to update information. Like she said, like with a will, when life changes, you should reach out to me and we should update some information. But other than that, it's inactive and there are no ongoing fees until I start acting in an active capacity. And then at that point, I start tracking my hours and billing by my hourly rate. Um, and then it just depends on what kind of service I'm providing. We may need to bring in, healthcare teams. We need, maybe I'm just talking to your financial people and helping you pay bills. It just depends on what the situation is. And every situation's really unique. Um,
That's what makes it fun, right? Nothing's the same.
yeah. And I mean, that for me, that's kind of part of why I'm drawn to the work is, I like the variety and always having to really consider and answer new questions.
Excellent. We had another question, and it was, how do we feel about co-personal representatives? For the same reason, I don't like them for other capacities. I don't like them as regarding the will or even as a trust either. If you are co-PRs, co-personal representatives, and I noticed what your sister is out of state and you're here, it's just going to be a logistical nightmare really to deal with it. The good news is, even if, let's say it was your mom and she named you and your sister as co-PRs, co-personal representatives, when the time came, your sister could say, I don't want to do it. And she signs a form that says she doesn't want to do it with the attorney you hire. And then you could do it yourself by yourself, or she could do it by herself if you didn't want to do it. So just because you're named co doesn't mean you necessarily have to serve it that way. But I still don't recommend you name co-personal representatives. I think it is really problematic. Um,
On to that.
yeah. The next question is, I no longer feel comfortable with all the people we selected for these roles described. These people are identified in our wills. What now? To make changes, then you would just have to update your documents. So you would do, I tend to recommend you just execute new ones rather than try to amend things and have codicils. And then you would replace the people with whoever else you were naming. Next question. If a person is named representative to someone's will and finds it's too much for them, like they live out of state, could this person hire a fiduciary to act in their place? Yes. And it can be easy to do that or it can be hard. If there's a lot of beneficiaries and you're disagreeing, that might make it difficult. If all the beneficiaries agree or there's just one beneficiary, then it can be super easy. Like I have clients who are out of state, and they didn't want to serve, so I've served in that capacity for them. So, again, as long as you have agreement. I know Kathleen mentioned, and I don't know if you caught this earlier, but there might be cases in probate. I know this is hard to believe, where the beneficiaries don't agree on anything, right? Not even who should serve as personal representative. And that's when the court will just make its own decision and typically appoint someone like Kathleen to take care of everything. So I think that answers your question, Shannon. Oh, thank you, Linda. That was very nice. She says, very informative. You both talk to us, not in any attorney talk. We do try to keep the legal mumbo jumbo at the door for sure. We do have 10 more minutes. I'm not going to keep you here against your will, though. So if you're ready to sign off, please do. Otherwise, we're still here to answer any questions and what ifs. And I know there's some questions that you threw out in the chat that I wasn't able to answer today. Because this is recorded and we're going to put it on the website, I really want to stay focused on these three roles and the applicability of Florida law. I can't speak to other states' laws, obviously, so I apologize for not being able to address those. With that, I'm going to just pause for a few minutes, but if you don't have anything else, I want to say thank you for joining us. If you're interested, next month, we're going to talk about planning for legacy, things like how do you take care of your pets in your estate plan? How do you take care of charities, nonprofits like your, college alma mater, that kind of stuff. So that'll be next month, the second Thursday of the month. And we are currently coming up with topics for next year. So if you have ideas on topics that you'd love to hear or guest speakers that you would love to hear, then please let us know. You can throw that in the chat or you can email Vicki, either one. So thank you all for being here. I want a special shout out to Kathleen Seide, who is, by the way, a board member of the Professional Fiduciary Council of Florida. So I am sure that she would be happy to answer any questions if you were curious about her services as well.
Absolutely.
Who?
And on that note, if you're looking for a professional fiduciary, website is a great resource for finding multiples around Florida. So it's always good to interview a couple people just to see, who's the best fit for you. And it's a great resource for that.
Excellent. A couple more questions came in. Do you have a preference in doing will over trust or setting up all assets with beneficiary? My focus in my practice is what's the simplest way we can accomplish your goal? Simple typically means least expensive as well. So the great answer to that, Deb, is it depends. If we can accomplish your goal with a simple plan, like beneficiary-based designations, then that's what I would recommend. But some people just can't do that. They have complex plans. They have out-of-state property. They have minor children, that kind of stuff. So that's your one talking like a lawyer today. What is the proverbial "it depends" answer? Deb, I'm a PR. I'm going to give this one to you, Kathleen. I'm a PR. What's the first thing that should happen after death? Attorney
I
question
mean,
mark, probate question mark.
call the attorney first,
Yeah.
I think, and go, make that mental inventory and secure property. So if there's anything that's really vulnerable, like for instance, if there's jewelry in the house, grandma's big diamond ring that everybody knows about, make sure you secure that stuff right away.
Mhm. Secure the doors if you have someone
Yeah.
that's shouldn't be
Change
in
the
there.
locks. Yeah.
Yeah. Mhm. For sure. Do that and call the attorney for sure.
Yeah.
Um,
And, you don't really have authority until you have the letters of administration, but does anybody else?
exactly. Exactly.
Yeah.
Next question. For next year, can you talk about Ladybird deeds? I can, and just so you know, and I do, in the probate avoidance lunch with Liz, which is up on the website, I talk a lot of, not a lot, but I do talk about Ladybird deeds and how they're effective for sure. Um, Next question. I live in 2 states. How do I manage this? One state has to be your state of residence, so that's where you would go to do all of your documents. Um, Jim says, "Hi, Jim. I'm a fan of yours too, Jim. What you think of having a legacy video as part of your preparations, and what should that look like?" I love a legacy video. I love a legacy book. There's books called like "I'm Dead Now What." There's the next of kin boxes. The videos are great, depending on what you're trying to articulate via there. But anything that you can do to give your agents, your healthcare surrogate, your power of attorney, your personal representative, and your beneficiaries guidance as to where your things are and what you want to have happen to them, that's great. Just keep in mind that the only thing that's really going to dictate it is the will, the trust, or your beneficiary based accounts. Um, Joyce, okay, thank you, Vicky. You took care of that for me. Um, to Jim, what do you mean? How should what look, Jim? And then while I'm waiting for that question, Deb P, is an attorney required for what, Deb? So, hey, Jim.
Hey Liz, um, I'm just I've done a couple of these. I produce videos, you know this,
Mhm.
and for some people, I've done pre-hurricane videos. Those diamond rings that your very informative guest just mentioned, and the location of all of those things, and especially the all-important will that bequeaths all of your worldly belongings to your cat.
Yeah, I think that that can be great to help with where things are and who they should go to. But I just want to make sure that everyone here listening knows that the video doesn't take the place of the writing, and it has to be in writing. So if you want your baseball card collection to go to your cousin, you want grandma's engagement ring to go to your daughter, it has to be in writing. You can do the video in addition to help identify the items, but the writing is what you really have to have. But I think, especially in cases of high end things, I think the video can be a great way to make it very clear that this is what I meant by grandma's engagement ring, not this, 1 carat thing over here.
As long as it's not your AI lookalike that's
Right.
saying things.
Exactly. And Deb, you said, is an attorney required? I just wasn't sure what you're referring to, whether an attorney is required. I don't know if Deb's still on here. Oh, okay. My mom has an out-of-state will valid here. So do I need an attorney for these letters of administration? So is an attorney required for probate? In the legal sense, no. In the practical sense, I would say that the probate rules are convoluted enough where probate is a very niche area because you really have to know what you're doing. So I think the practical answer is yes, you would need an attorney to get the letters of administration. But the will would be probated wherever your mom lives. So if she lives here, it would be probated here. If she lives in another state, it would be there. So any other questions before we wrap this up? Oh, we have one more question. If a husband is appointed representative or trustee for someone, but the wife is technically better, well, duh, about making phone calls, etc., can the representative trustee give places permission to talk to the wife? I will just tell you in practical terms, it just doesn't work that way. It's the person with the letters of administration who would be the one talking. There's obviously, you can see the legal issues on the other side. They want to make sure they're dealing with someone that has been named the fiduciary, is under the bond by the court. So it's very rare that you would be able to give these powers to somebody else. It could happen, but it's very rare that it would work out that way.
Can I add to
Yeah,
that?
absolutely. Yeah.
Yeah, so you can't give away your fiduciary role, right? You can't hand that off to your wife or whatever. But you can basically hire out those lesser tasks. So like when there's a house in the probate and I need lawn care, I can have my assistant call around to get quotes for lawn care, and then I will make the decision about who to hire and I will sign the contract, right? So it's for me to make the decision and sign the contract, but I can have someone else do some of that legwork. But like a bank won't talk to them. I have to be the one that's sitting there for 2 hours while they type on their computer, even though it's stupid for me to be sitting there, right? So yeah, like she said, a lot of it you can't hand off. But there are some things that you can hand off that are those, getting quotes, meeting someone, meeting the junk removal people, things like that, that are just, but I don't know if your wife's going to want to do that.
Right.
I'll pop in on that one too. I guess my camera's not working, but yeah, my concern is this. I'm finding out that I'm personally getting named on several people's wills, but there's one in particular. It's not necessarily the will, but like I have friends that are older and they have an autistic child who's 24 and will need long-term care. And I know this is not quite in the same, but sort of, because I'm getting a little overwhelmed with everybody appointing me, or my husband rather. So some of them are talking about making us have us both on the account when you guys are saying not to, but he works. I don't necessarily, we're both good with money, but he's a little bit better with money. I'm a little bit better with talking to the people. So we just act as a team. So that's my concern, is not trying to not get all overwhelmed in the situation where we've got all these people appointing us. So
Yeah. And I think
it hurts to be responsible sometimes.
it does. It does. Two things I want to say to that is one, that this sounds like a lot more than what we could really address here.
Sure.
But number two is keep in mind that just because your name doesn't mean you have to serve. You can always decline the appointment to anything, healthcare surrogate, PR, power of attorney. That's why it's important as someone who's drafting your own documents that you're not naming someone that you haven't had a discussion with.
Right,
You don't know that they even have the capability of serving
right.
or the desire.
Like in my case, and I'm sure others have this too. My father's trying to get me to be executor of my aunt's estate up in New Hampshire, and I'm like, I'm already the executor in theirs, you know. So it's like, you know, even being an executor in another state seems like it doesn't make sense.
Yeah, and I think that's where you have to have some tough love, maybe that I appreciate you wanting me to do it, but this is not
Yeah.
something that we can do.
Okay.
Yeah.
You guys giving me good things to say. Thank you.
Awesome. Awesome. Nice talking to you, Shannon. And then
Good.
Kathleen, Karen wants to know how to contact your office. So Kathleen, if you could throw that in the chat, that would be great. And with that, I want to thank you all for joining Lunch with Liz today. I hope you got some information and it was informative and helps you either become an agent under one of these roles or helps you choose the person that is going to be in that role. And Kathleen just put up her website and her phone number. So if you would like to contact her, that's there. So happy Thanksgiving. Have a great rest of your month, and hopefully we'll see you back on December, I think, 4th. I think we're doing December 4th this time. It's actually the first Thursday of the month next month due to the holiday. So, all right, everyone. Thank you. Appreciate it. We're going to clear off. And again, thank you, Kathleen. Really appreciated it.
It's a pleasure. Thanks for having me.
You bet.